Good morning and welcome to the webinar on blockchain technology and smart contracts. Yesterday afternoon, we had a very interesting webinar on security rights on digital assets and the fact that this is a bit connected. It's about IT and law, particularly the private law aspects of IT. We will first start with a short presentation of the state of play of the ELI project. And it's a pleasure to give the floor to my co-reporter for that project, Martin Hansel. He is an associate at Ernst & Young Law, Peltzman Gellengroos Rechtsanwälte in Vienna. And Martin, it's a pleasure giving you the floor.
Many thanks for the introduction, Chef. And yeah, I'm happy to start this meeting and to give a short overview of what has happened within the blockchain technology and smart contracts working group over the past year. Today, I, as a representative of our working group, will present to you our draft structure and also some selected principles that we think are essential for our project. Starting with the draft structure of the report, the first part of our report will focus on scope and definitions. The principles in our report are intended to serve as some kind of general guidelines which give a first orientation for the handling of blockchain technology and smart contracts from a private law perspective. And this is also one of the so-called limitations that we have in our project, because the scope of the principle is limited to private law aspects, and therefore when blockchains and smart contracts are used in this setting and not on the public or regulatory, and does not focus on public or regulatory or other sandbox aspects. Another limitation of our report is that we deal with transactions on the blockchain, which means that a transaction on a blockchain in our report, in our working group, means results in a change of state on the blockchain, which is, for example, a transfer of cryptocurrencies, which leads to a reduction of the amount of cryptocurrency that the owner of private key A can dispose of, and increases the amount of the owner of private key B, which means it's a basic cryptocurrency transaction. Furthermore, these transactions should be of some kind of contractual nature, as we focus on the private law aspects. But this includes the whole life cycle of such contract, from the contract formation, the performance, and also post-contractual stages. As you can see, therefore, other aspects of private law are excluded, such as the creation of rights in REM, such as security rights, and also questions regarding access to digital assets. And Chef has already outlined that there is another ELI project focusing on these questions, especially on access to digital assets. So it's definitely worth to also check this project out. And furthermore, as you can also see on the slide, as a starting point, we took the ISO definitions, discussed them within our project team, and amended or supplemented them when necessary. However, the definitions given in our report, they should only ensure that the reader and the project group team have the same understanding of certain blockchain-related aspects. But it is not our goal to establish a whole new set of definitions, as the emphasis of our project is definitely on the principles and not the definitions. You can also see it on the slide here in part 2. The principles will focus, amongst others, on various topics, as I said, on the scope and therefore also on the limitations of the project, and the various types of smart contracts, private international law aspects, which we'll also have a closer look at later, and also other questions that are important with regard to the whole private law settings, such as the effectiveness of transactions, unfairness control, and on-chain arbitration. To give you also some kind of outlook for what will happen in the next few months, we expect to deep dive into consumer protection, also the protection of weaker parties in general, and therefore also give our report a stronger emphasis on these issues. Now, let's go to select the draft principles. We would like to give you an overview of principles that have already been discussed within our project team. Starting with draft principle 2, as I said, we distinguish various types of smart contracts, namely 4 types. Number 1, the smart contract is the legal agreement. In this case, we argue that the smart contract itself, the code, so to say, constitutes a legal agreement. Number 2, that the smart contract is mere code and that there is no legal agreement related thereto. In this case, the situation is that a mere transaction, a technical sense, that the smart contract is a mere transaction, a technical sense of the word, and that neither the smart contract constitutes the legal agreement, nor that there exists any other agreement off-chain. Number 3, probably at this time the most common type of smart contract, that the smart contract is a tool to execute a legal agreement, and that a legal agreement exists off-chain. So in this scenario, the scenario covers cases in which an off-chain agreement exists and smart contracts are used to execute certain rights and obligations on-chain. And as you can see on the slide, the last type would be then that the smart contract is merged with the legal agreement and that it exists therefore both on-chain and off-chain. And in this situation, it has to be determined which agreement should prevail, and whether it should be treated on-chain or off-chain. So that's so much to the draft principle 2 and the various types of smart contracts. We would then also outline or go to draft principle 5 on the next slide exactly, which is also connected to the first type of smart contract that we identified in draft principle 2, namely that a smart contract can be a legal agreement. We have discussed this principle very intensely within our group and have now finally come to an agreement of a draft wording at least, saying that the triggering of a transaction or elements of a transaction performed on a blockchain can have a legal meaning. So basically, the first part of this principle says, yes, we do think that smart contracts can also have some kind of legal effect. And so this is the first part. And on the second part, we put it into context and say, and argue that although these smart contracts can have some kind of legal effect, we always have to put it in context, and it should only have legal effect where a triggering of a transaction can reasonably be understood as some kind of declaration of will and is also attributable to the relevant party. So that means that we do still have to take into account that the new technology of smart contracts and blockchain, and therefore set these smart contracts used in some kind of context in order to so that they can have some kind of legal meaning. This is basically the draft principle and explanatory notes in a nutshell. And as I said, we will also have a look at private international law, namely the draft principle 4, as this has also been heavily discussed within our project team. That's why we wanted to conclude this presentation with this principle. As I see that I'm running out of time already, we will just have a very short look at the private international aspects. There are mainly, you can see the principle on the slides, and we have mainly 3 aspects related there. So in the first paragraph, we clarify that transactions on the blockchain are subject to the rules of law that would apply to functionally equivalent acts outside the blockchain. That means that also includes private international law aspects. So we just have to take that into account when talking about blockchain. then in the second paragraph, we just outline that choice of law and choice of forum is in principle possible. And in the third paragraph, maybe it's something that we probably the thing that we have been discussed the most within the project group is that the mere fact that a blockchain on which a smart contract is stored or executed is decentralized, not by itself constitutes an international dimension of said smart contract in the sense of private international law, meaning that only because a blockchain is usually, or the nodes operating a blockchain are usually distributed internationally, that does not necessarily constitute that every smart contract operating on said blockchain has an international dimension in the private international law sense. So that is one of the key meanings of this principle that we wanted to put focus on. And yeah, that's in a nutshell what we have been working on over the past year, and I'm very much looking forward to comments and questions.
Thank you very much, Martin. Yes, we've had quite some debate within the working group on the legal nature of algorithms, because what is happening, let's say, in an algorithmic and a coded environment, can that have legal consequences? And if so, which? And also had quite some debate, so as you say, about private international law. And basically also in our Access to Digital Assets project, private international law proves to be one of the most difficult problems to face, because you need to know which law applies before you can start answering questions. Okay, what are the legal effects? Right, well, thank you. The second speaker on our panel is Marina Niforos. She is an affiliate professor at HEC Business School. Marina, the floor is yours.
Thank you. Good morning, everyone, and thank you very much for your invitation to participate in this panel today. So I should start perhaps for the audience of making a little caveat. I believe I'm the only non-legal scientist on this panel. So my perspective and my comments today would be more that of an economist and a representative, let's say, of the private sector or innovator, let's say, side, of which I've been accompanying since 2016. So I have been involved also on the policymaking side of things, starting with work that had been done at the World Bank, the International Finance Corporation, and later on with the European Blockchain Observatory and Forum. And I was also one of the co-authors of the report that was done on the legal and regulatory framework for blockchain and smart contracts, which was done in 2019. So I applaud this initiative because I believe it's extremely necessary for the legal profession and for us to work together, those from the private side as well as from the policymaking side, to make sure that we advance this very important topic and to bring progress into providing more certainty, let's say, as to the legality that surrounds economic use cases that involve distributed ledger technology or blockchain, and specifically smart contracts. I also understand the enormity of the task that the project team has undertaken. I know for us as well as a group in 2019, when we started the work at the observatory, it was extremely difficult to put a perimeter around what we should look at and how we should approach it. This is an extremely complex subject. The technology itself is foundational, and it's very potential. I mean, its main attributes that engender its huge potential for re-engineering economic models are also at the root of many of the problems in terms of the legal implication it has. So its capability for decentralization and disintermediation, its immutability, its anonymity / pseudonymity, and its automation are the very things that then we have to tackle from a legal perspective and see how we accommodate as innovators are pushing the boundaries of what is considered to be the spirit and sometimes even the letter of the law. In the terms of this particular report, I was very heartened to see, even though it's outside, as Martin just said, of the scope of the report, that it emphasized the importance of having a complementary approach with a regulatory sandbox, so that both policymakers and innovators could actually work side by side in a very hands-on approach and try to find solutions together. And I'm a very firm proponent of that. And I think also the observatory, in both its previous and its current mandate, spoke very strongly about this issue. And I'm very heartened to have seen that the European Commission has announced that there will be a sort of pan-European, at least it supports the idea of a pan-European regulatory observatory, a sandbox, sorry, that will allow sort of all of the member states to kind of have a role. And it would look at smart contracts not from a purely financial services perspective, but it would allow a lot of many other use cases and therefore encompass all of economic activity. Turning to the report itself, I was also very heartened to see that there will be existing work being done on the issue of liability. And this is sort of a persistent principle one, I believe. I'm not sure I'm getting the numbers of the principles correctly, but you know, this is a question that is also one that is of tantamount importance to try to shed more clarity, because it regards, as you rightly pointed out, the question of protection of consumers, but not only, I would say. I would also venture to say that it's also an issue for investors. And as we move increasingly to economic models where the line between consumer and productive economic agent are blurred with prosumer models, it is all the more important to start delineating the roles and ensuring that there are proper frameworks for the accountability. And this will be particularly challenging the more permissionless and more open the blockchains will be. So the question of who bears damages, who is accountable in the more distributed models will be very challenging, and we will be looking forward to the legal innovators to provide some guidance, let's say, if not some legal foresight yet. I also supported very much, and I was heartened to see that there is an exhortance for a more balanced approach. So I saw in your report that you stressed how important it is to not go ahead with very fast and rigid rules off the bat. I think we all recognize that this is a technology that is still in a highly evolutive phase. We're still at the beginning, I would say, even though we've come to a level of maturity the last 4 or 5 years, but we're still a long ways to go. We're still mostly in the POC phases in many initiative and use cases. So it's important to, as you say, balance the ex ante certainty with the ex post fairness. So a balanced approach is what is required. This will be an organic almost process. Moving too fast with some very rigid taxonomy will provide certain benefits and safeguards, but it will probably stifle innovation. Not giving enough, we can sort of risk the fact of creating too much uncertainty and not crowding investors, or even prohibit illicit activities that may happen. So this is a difficult exercise of equilibrium that must be struck, and the role of the legislator and also the implementers, even within companies, is going to be difficult. Where I would like to see perhaps a little bit more clarity will be on principle 4 and sort of on the triggering mechanisms from a legal perspective on you know, the private international law clauses. It's still not clear to me from the current analysis, and I think for many business users, where would their liability lie? Is it what constitutes a cross-border element, let's say, in a transaction or in a commercial relationship? Would the nodes itself, which are by very nature distributed, be parties to such transaction or not? So I think there we have, you know, you have a lot of work to do with other colleagues, and there again, I think international collaboration is very important. Sometimes we have the notion that we can just rely on existing legislation that points to you know, where the person that actually consumes the ultimate, let's say, part of the transaction. But I think the complexity of the underlying infrastructures and the choices that the use cases make in that type of infrastructure will make it a little bit more difficult to be so simple in the decision making, and more work needs to be done. Again, the asymmetry of information that you noted in several areas between, let's say, consumers and other economic participants. It is noted, again, I stress that might not be an asymmetry just for consumers or individual consumers. It might be also for investors, micro investors, but I would venture to say that even for users who are not technologists, this still remains a challenge. And I think some safeguards can be included, and I see you have included them, for example, in Principle 9, where you kind of privilege off-chain contracts because they're more, let's say, legible from a legal point of view. But I would venture to say that it would be also important not to just rely on that. That is, for me, a necessary transitory safeguard, but we shouldn't neglect the underlying real problem, which is we need to continue to educate all of the users into the elements of the technology until we're all comfortable that we have at least some familiarity. We cannot avoid that, and it's something that we don't necessarily address very often, that this needs to be part of the multidisciplinarity also of our pipeline of talents. As we're thinking as an educator and someone who's concerned with reskilling, this should also be part of the things we are thinking of. We need more lawyers that think that scientists, computer scientists that are more aware also of the necessities of the legal profession. I think I'm abusing my time, but if I have to add one last comment is I would also look towards more clarity as to an area you postulated, the question of functional equivalence and technological neutrality. If I read it correctly, you kind of make an allusion of how basically the internet governance rules kind of evolved, and that we can learn from that in terms of building successively as the innovation evolved, but trying to move towards common technological standards and then trying to innovate as closely to the margins of the existing legislation as possible. But I look to more guidance towards that. And last but not least, I particularly appreciated the idea of innovating also legally using the technology. So the on-chain arbitration example was particularly interesting. And I think the private sector would like to understand also a lot more how we can actually use the technology as a means to innovate legally as well and integrate some of these, challenges and how to face them on-chain as well as off-chain. So I leave it at that. I thank you, and maybe we can continue at some other point in the discussion.
Thank you very much. Those remarks you made were extremely useful. I can tell you that in the beginning of the project, and still, we work closely together with computer scientists, so let's say more technical people. That's not always easy, because lawyers have a different language than programmers, not just because programmers program and lawyers speak a natural language, but it works out quite well. Some of the points you indicated about, let's say, liability and private international law are certainly points already debated within the group. So we take good note of what you said, and I'm sure in the discussion that will come up. Already we have one question. So, all right. Now the next speaker is Claudia Sandé. Welcome. She is an associate professor of company law and IT law at the University of Padua. And Claudia, the floor is yours.
Thank you. Thank you for this invitation, and good morning, everybody. As Marina, I'm also part of the European Blockchain Forum, and as Marina, I share a different perspective, which is not really the private law one, but as I'm a company professor, my interest is more focused on companies and the opportunities that blockchain offers to small business and in the financial law. And according to this, we run a lab in Padua whose name is Innovation and Technology Law Lab. And with this lab, we cooperate with some businesses. They ask some advice and so on. So I had the chance to look into some practical projects, I mean, relating to the blockchain and smart contracts. And this helped me a lot to get some more knowledge about what are the real problems we are experiencing in translating what we think the result we think as a lawyers to have achieved, and so and then what businesses need us to know, and sometimes we miss some clarity. And I have just a few remarks. The first one is related to digital assets in a way, because I appreciated a lot the definition I found here about digital assets, like things that are converted into the blockchain, because I think that while smart contracts, as you outlined in the report, can be signed also offline, of course, their content must be related to digital assets. Otherwise, automation is not functioning properly. So the problem we have is to reconcile the online world with the offline worlds. And for this purpose, I think that a legislative intervention is needed, because how can we arrange this discrepancy that can arrange, for example, if a person transferred the digital asset, but on the other side, he also gives possession to another person, and this I think is something we should try to solve. And in company law, with the shares that are tokenized, this is a problem, of course, we need to solve. And the second point is related to standards, because in the report, I know that this is a minimum approach in a way. And so in the report, you say maybe we have to distinguish between private blockchain and public ones, between permissionless and permissioned. And this is exactly what the Italian law did, because we had a legislation a couple of years ago on blockchain, which is a minimum legislation. It just says that blockchain is valid and that it is up to the judge to decide which force, which effect to recognize to the particular blockchain, which seems to be something that allows flexibility, but at the same time, businesses ask, and so what? So what can I expect? This is an evidence in a trial, or this not? Because what happens is that sometimes the case I saw, that I worked on, was related to a leasing of machineries, and then on the blockchain there was this smart contract, and also how many hours the machinery should work. So there were some evidences that could not be found outside the blockchain, like the smart contract. So you can conclude, you can sign the smart contract outside, but then there are some facts, parties may want to register on the blockchain, so it can be useful to say, okay, if you have more than 5 nodes, that is reliable. Or if you have some rules that guarantee that nobody can modify because there is not a super node, this will have a more value in a trial, or something like this. So I think that saying that we will see in the future when the trial arises and when the problems arise is something that from the point of view of businesses is not so fascinating. I mean, because they like to have more certainty. For example, written form is enough. So I think that some standards could help to develop smart contracts. And at the same time, even if this is not related actually with the paper you prepared, but this can also help the development of smart contracts, is that we have maybe to reflect also to the service agreement, because people run the smart contract on third parties blockchains. And so before joining the smart contract, they have to accept the rules. For example, how many days the smart contract will be maintained after expiration on the blockchain, or for example, confidentiality, or other stuff like GDPR or security. And you know that in Malta, for the financial world, there is an auditing which is compulsory. So the law asks people that want to transact in digital tokens to have an audit, to certify that this smart contract is fair, so that it is exactly what people read in a natural language, that it is secure, that there are enough standards employed. And so this is, I think, these are some remarks, and some of them are out of the scope of the report, but I think that those are some questions people are wondering to explore in a more detailed way from the law perspective. And that's all for my side.
Okay, Claudia, thank you very, very much. Just already in a brief reply, just quickly, would you say about particularly digital twins, for instance, that is dealt with in the other project, in the Access to Digital Assets project? And of course, you're completely correct that this project is in a way related to access to digital assets. And in the Access to Digital Asset project, it is heavily debated what to do with the applicable law regarding the real world asset if there is a token. Because if you transfer the token, is it a transfer of the real world asset or not? There's quite some debate about that. And yesterday we had panelists from Unidra, and also Unidra is working in this area, and also they have debates. And because these really are, as you say, the questions. So some of the points that you put forward are dealt with, but in another project. But it might be, and that could be the advice that you give us implicitly, that we somehow have to connect, let's say, what we write with what is happening in the Access to Digital Asset project, so that it becomes clear that we see that problem, and that there is another project where you can look for a possible solution. But thank you very, very much. Those comments were, again, extremely useful. So thank you, and we do take note. Our final speaker is Dirk Stonemeyer, and he is the head of unit for contract law of the DG Justice and Consumers at the European Commission. Dirk, the floor is yours.
Thank you very much, Chief. Good morning to everybody who is joining us. Thanks a lot to ELI, to the organizers, for this invitation and this panel, which was a very interesting subject. And that brings me straight away to what I would like to speak about, because I would like to start my presentation to explain very briefly why the EU, and EU means in this case the Commission and the Parliament, is interested in smart contracts. That's the first point. Second point is, what are we going to do in the near future? Because we are going to do something. And the third, I'll allow myself a few comments on the ELI project at the state as it is now. So first of all, why is the EU interested in smart contracts? For the Commission, and I start with the Commission because I belong to the Commission, there are two aspects which I would like to mention. First of all, the smart contracts have the potential to allow companies, and that means especially SMEs and startups, to undertake transactions without the need of intermediaries or trusted third parties. So therefore, if we promote the uptake of the blockchain technology and smart contracts, we promote and help startups and SMEs. And indeed, one of the Commission's objectives is to help SMEs and startups, particularly after the pandemic. In the Europe Moments communication of 2020, dealing with the European recovery following the pandemic, the Commission underlined that a fairer and easier business environment is one of the key elements for digital recovery. And in that context, it stresses the importance of, I quote, making it easier for companies, especially SMEs, to use digital tools and to reduce red tape through digital solutions, for example, for contracts. And that's where our work on smart contracts is anchored on. The second reason why we're interested is smart contracts can help consumers exercising their right over their personal data. And here I go back to the Commission's data strategy of 2020, last year, because it highlights the potential benefits of the blockchain in the context of data management. Because here we can empower individuals to exercise their rights. And the data strategy mentions the needs to give individuals the tools to decide at a very granular level what is done with their data. That can be done by the classical ways of consent management tools and personal information management apps, which would use trusted third parties. But it could also be done through fully decentralized solutions building on the blockchain, i.e. smart contracts. And the data strategy explains that while currently such tools are still in their infancy, they have a significant potential and they need a supportive environment. So the idea is, in order to empower individuals with respect to their data, to support them in A, using their data, and B, enforcing their rights as a data subject and as a consumer. And that could be done through smart contracts. You could imagine a template, for instance, where you can tick some of the boxes and say, I grant the following people access to my data for that purpose, that duration, and that counter performance. And then basically, if the data are used within these limits, it's all fine. But if somebody trespasses these limits, the access is cut off. That's the self-exercising force of smart contracts. So that's the idea behind. Now, what's the Parliament interested in? The Parliament adopted in 2020 an own initiative legislative resolution on civil and commercial rules in the context of the digital economy. And in this resolution, it highlights the increasing importance of smart contract and calls on the Commission first to assess the development and use of the blockchain and smart contracts. Second, to provide guidance to ensure legal certainty for business and consumers. And third, to make proposals for an appropriate legal framework. Now, in our answer to the Parliament, we announced, among others, that we would do two things. We would carry out a study to analyze these questions, and second, to launch a consultation. And that's what we're going to do. We're going to launch a pilot project, which is specifically financed by a special budget of the European Parliament. And we will launch a targeted stakeholder consultation. I'll come to that in a minute. But it's interesting that the Parliament, in its comments, when it gives us budget to do these things, points specifically to the need to establish requirements in order to allow for smart contracts to constitute legally valid contracts under the contract law of member states, and underlines the needs for such requirements to safeguard the interests of European consumers. So on both aspects, you can see very clear links to the ELI project. So what are we going to do in the near future? Basically, we will launch a pilot project, which will consist of two work strands. The first work strand will look at the applicable rules, so what exists, and are they limiting, preventing, or in any other way make it very difficult to use and deploy smart contracts. And then we look at these limitations, if we find some, and whether they're mandatory or not, whether they constitute obstacles for the cross-border use and deployment of smart contracts, and how the rights of citizens and consumers can be ensured. And as the second strand of this pilot project, we do a case study, which looks at this data management tool based on smart contracts in B2C contract relations, and check at the feasibility in the commercial, technical, and legal terms, especially for the benefits of SMEs and startups as consumers. And in parallel to this pilot project, we will launch towards the end of the year a targeted stakeholder consultation to discuss this with stakeholders. So for these reasons, we're very interested to cooperate with the ELI and its projects. And given that my time is coming to an end, I would like to make only two comments on the ELI project, where I see some synergies, but also some interest, considerable interest for further development. The first one is on B2C contract law requirements. So the project, the ELI project, stressed that in general, the existing, in the acquis, existing B2C contract law requirements can be maintained in a smart contract situation. And indeed, rightly, it points out that it matters that parties know what they want to achieve, and it does not matter how they want to achieve it in terms of technology used. I understand that so far the project team, and Martin Hansel mentioned something like that at the beginning, has not yet done a systematic assessment of the existing requirements in B2C contract law, but that is intended to be done. Now, we're very aware that the ELI project is sailing here into uncharted waters, but we're very much looking forward to result. And we would like to sail on this travel with you. And the second point I would like to mention is civil law form requirements. As form requirements could prevent the use of smart contracts in use cases. So for instance, take a written form requirements for a bill of lading, which should be tokenized. The ELI draft report also contains a principle that using smart contracts could satisfy certain form requirements if they serve the same purpose. So the principle of equivalence, which we know also from the UN Convention on e-commerce. For us, it would be now very interesting to know what kind of form requirements would be satisfied by what kind of features of smart contract. That's the second element. I'm really, really curious to see the further work of the ELI. So in a nutshell, we are concluding, as my time is at the end, concluding basically this is a fascinating area. This project and our work on smart contract is part of a bigger process which is going on, which is creating the private law of the digital economy. And for this, I'm very much looking forward to the cooperation with ELI on this project, and I'm looking forward to the discussion after this panel. Thank you very much.
Thank you, Dirk. That was very interesting. And what you were saying is, I think, very well heard by both Martin and me, and I think the ELI as such. So thank you. We have, and I'm really grateful to all of you for staying within the time limits, because we have, I would say, for a question and answer session, we have a host of questions. I think one question we could deal with immediately is to share the Italian law. Well, that is quite easy. Claudia, you could do that, but in fact, Martin and I, in fact, have the text as well. But I think that is really easy. So the answer to that question is, can you share that answer? Yes. The first question, and I think that was already there when Marina was talking, is, do you think that the public contracts should have a particular regime regarding the application of smart contracts principles? So public contracts. So, and because the question came up, Marina, while you were talking, I now address you. What do you think about public contracts?
I'm not sure exactly what the specific nature of public contracts in the way they're stated would be. Would those be contracts of public law nature? Is that what the nature of the question is?
I think so. I think this is all what the person who was asking the question writes. And I think that is what is meant, contract by a public entity, so a government or a government agency.
Well, I don't think I'm really qualified to answer this question because it's of a particular technical nature. So I will perhaps pass this question to someone who would like to answer it from the panel.
Okay, all right. Perhaps Martin or Claudia?
Yeah, I think that also the formal point of view is interested, because when public contracts are dealt, then there are some more formal requirements normally, and so this can also be a problem for smart contracts, as smart contracts try to deal with the simple electronic signature. Well, we will see the revision of the European identification regulation, so maybe it will be easier then. But presently, I think that the formal requirements can be an obstacle to the smart contracts.
Okay, thank you. The next
If
question.
if I may just add,
Yeah.
again, this is not a legal answer, but also belonging in a government body or a semi-government body that has to do with a lot of state-owned enterprises. The complexity, for example, of procurement procedures regarding public entities can be extremely more complex from a legal point of view. So if smart contracts are involved in that area, I would presume that even more caution should be exercised, and it would be much more necessary to provide some guidance on how a state-owned entity or a government entity should function under that regime in the case that they might use smart contracts in government to government or government to business related projects.
Okay, thank you. I think, Martin, the next question is aimed at us. It is about, let me see, the use of, now my computer is creating problems. It's about the use that we make of the ISO standards. Is there any international cooperation on that you know of?
Not really. I mean, not specifically for blockchain at least, but I think we took the ISO standard definitions, maybe also as some kind of explanation why we took them as a starting point for our project. We took them as they have some kind of a technical approach and give some kind of good guidance at the beginning for lawyers also to understand better what we are dealing with, and that's why we decided to use the ISO standards. But I'm not aware of any representatives from the EU to coordinate. But I think Marina wanted to add.
There are several initiatives, including under Stand ICT. As well under INATVA. I know that INATVA has dedicated committees that are working on it, the International Association of Trusted Blockchain Applications, which was created at the same time as the EBSI and a little later than the European blockchain. So it brings together businesses, startups, and other associations around blockchain in forming working groups. And I know they have groups addressing standards, governance, interoperability, and security questions. And I know there's participation of the EU at the ISO task force that is looking into standards for blockchain, the International Organization of Standards.
Okay, thank you. The next question, Claudia, is for you. It is about how important do you think it is to bring DAOs into the mainstream company law?
Well, I think that DAO is a mainstream because in the company literature there are a lot of articles in this related to this topic right now, and I think that it depends what we mean for DAO, because if it is an investment fund, as it were, okay, maybe it's more similar to algorithmic trading or something like this, but from the company point of view, there are some issues we need to solve before, like management, which is not anymore a natural person, and the liability and the concept of legal personality. So there are some big topics that need to be addressed before we can admit DAO, even if some other states like Wyoming, they just ruled on. And so, but they are different. I mean, in Europe, we take care of principles, and I think it's a good idea to maintain them.
All right, thank you. Now, I'm going to skip a long question to ask another question, because the questions are rolling in. This is really good. But this question, I think I should ask the panel. It is, I'm an old-fashioned lawyer and EU law researcher. Now, in my approach to private law issues, I'm always interested in the pathological aspects of contractual relations. Now, do the pathological issues of a contractual relation, are they adequately taken on board under a blockchain transaction? how a private party can protect his or her interest in cases of, for instance, delayed, wrong, or non-compliance to the contract. So more generally, is the electronic transaction legally binding as a traditional one, and when is binding character, when its binding character emerges formally and even beyond the bilateral relations, but even with a public relevance? I think, Martin, that is a question basically to you and me. And I can already say this is exactly the point where we had hour-long debates in the working group. But the floor is yours, Martin.
Oh yeah, then please feel free to add your side of the story. Yeah, I mean, in this question there are lots of different questions, and as you have already included in one question, as you have already explained, we have had very much discussions about it, and then we decided actually to focus in a first step on the question whether from a merely private law perspective, the transactions taken on a blockchain as outlined in the draft principle 5, such triggering of transactions, etc., could have some kind of legal meaning, and we concluded yes, this could be the case. And then this question is actually directed at the second part. How can we, now that we have established that there is some kind of legal meaning, or there can be some kind of legal meaning within the blockchain context, how can we make sure that others or third parties also comply with these legal facts that have been established on chain? And this is a question, which is quite hard to answer, as it is more from a technological perspective as well. We discussed it with our technology experts, and we think that, for example, to unwind contracts, reverse transactions could be a possible solution, and that there is some kind of that there are possibilities to for example unwind those transactions. However, it is hard to enforce for example a legal effect on chain, as you do not have like a centralized court or that could enforce it purely automatically on chain. So this is actually an issue that we are tackling, or that the technology experts will have to tackle on chain. And yeah, so but I think that's
what is absolutely clear is that what we see happening in practice is that blockchain transactions are considered to be valid transactions, even without an existing legal framework. In practice, participants consider what is happening on a blockchain as legally valid between them. And that is our starting point. And in that respect, blockchain technology, smart contracts are not different from other types of software, like from sending one another emails, because then you also use software to express what you want. So our starting point is a transaction on a blockchain, a smart contract, may be legally binding, but it of course depends upon the type of smart contract, the type of transaction. And then we have to take technically into account that what happens on a blockchain is immutable, irreversible. So let's say if a contract under normal circumstances would be considered to be void, it meant that, what has been given on both sides has to be returned. But on a blockchain, that cannot immediately happen. You have to undo the transaction. So rewinding it, unwinding it, reversing it becomes of great relevance. And that is in fact what we're focusing on. And when we will do further research on consumer law, these are the aspects we will look at. That a contract on a blockchain, for instance, is what some authors now call is a dark contract. You have no idea what's going on. Companies using blockchain can abuse that by hiding what is going on legally. So how do we protect consumers against that? And also our advisors asked us not just to look at consumers, but at weaker parties generally. Because what happens in other situations where it's not a consumer is a counterparty, but another weaker party, like in employment law, for instance. I don't know if we can look at all of these weaker parties, we will concentrate on consumers, but there's definitely a problem there, and we are very much aware of that. But our starting point is what is happening on a blockchain may have legal effect, and that is a starting point. What does it mean? And how can we create a situation that protection that is given, for instance, to consumers off-chain is exactly the same as on-chain? We are very close to to the end of our webinar, and when I say questions are rolling in, one question, yes, is of a more political nature. It is about, it sounds as if the EU initiative is an attempt to automate administrative processes by the public sector in the same way as the Industrial Revolution used machines to do the work that humans were doing. I'm not so sure whether that is the intention, but perhaps, Dirk, you would like to reply briefly to that point?
I'm not so sure I understand the question correctly, I have to admit, because what I was trying to explain does not really concern the public sector and administrative processes. It concerns, on the contrary, it concerns commercial transactions between companies or between companies and consumers. Obviously, it's very clear that we are in a process of the second machine age, or which is a process which is comparable to the Industrial Revolution, actually only to the Industrial Revolution, or the settling down from hunters and gatherers to become farmers. That's very clear, and that has huge impacts on our economy. The smart contracts could be one, and the blockchain could be one tool in there to make this transition smoother, basically. But there is also clearly a broader trend, which is to say, if you have this transition towards a digital economy, you need to provide a framework to make it smoother, but also to make sure that certain fundamental values of our society and economy are safeguarded. As I said, I'm not sure I understood the question properly, but I hope my answer gives at least some elements for consideration. Thank you.
All right, thank you. Well, I understand that we do have a little bit more time, and the questions are rolling in. For instance, in the digital, we see it says Digital 360 article. I don't know exactly what is meant. It states in Article 8.2 that the smart contract satisfies the requirement of the written form. Does this apply also to wills?
Well, I think it's for me because I was not able to copy all the article text because there are dimension constraints in the question and answer. So I just published the link. So he's referring to the link. And the question is if we can also make some wheels through these smart contracts. Well, I've never thought about this, and probably I would say no, because we can't have a digital will presently. I mean, because we need to have written form in a typical way, and otherwise you need to go to the notary. What can we think of is to have a smart contract with it executes the will, and maybe, well, why not? But this is a private law question, so
I would be.
It's easier for me to say I'm not a private law professor.
No, I think I would be more hesitant. This is, in fact, the same debate that you can see with regard to digital twins. In case you tokenize immovable property, can then transfer of the token be considered to be a transfer of the immovable property? And in the access to digital assets group, we decided, but that was related to questions of security rights on digital assets, that we then separate what happens with the real world asset be separated from what happened with the token for reasons of public policy. Because if you have strong rules regarding real world assets, like in the case of immovable property, where generally in the European Union, the rule is that you need a notarial deed plus registration, then it would go against public policy, I think, in all member states to say, well, but you can also transfer it using a token. And I think that is a problem that plays a role when you say, well, could a smart contract replace a will? If a particular national legal system allows, let's say, handwritten wills, maybe yes. But can it then replace a notarial will with the effect that a notarial will has? That is another matter. Then you, so this is quite a complicated area, but it's a really good question. Well, let me see. There is a long question from Christoph Busch, and let me read it. I have to. Let me see. Let me go through it. In my view, he says, it is an excellent idea to explore how compliance with consumer law can be ensured in a blockchain context. In the field of platform regulation, there is an emerging trend towards involving platform operators as regulatory intermediaries who have a co-responsibility for ensuring that business users of the platform comply with consumer law. It might be interesting to explore whether and how this model can be transferred to a blockchain context, considering that there is no single centralized intermediary, maybe several decentralized intermediary, like wallet providers, crypto exchanges could play a role as regulatory intermediaries who have a co-responsibility for ensuring that transactions comply with consumer law. And he writes that one of his PhD researchers is working on this and what the view of the panel is. Well, it's a question to the panel, and I thought already, Marina, that would be a question for you. So please.
Again, I will speak only for my colleague who actually has written on this subject. So this is Gordon Myers from the IFC, and I can publish the link in the chat. He put forward a very similar idea as to how we could look at how the internet evolved and how we progressively, through either case law or even legislation in some national jurisdictions, we came to apportion, if you have responsibility or accountability to platforms in terms of certain issues, including data protection or even liability, etc. And so he used that as a proxy to provide some solutions. Particularly, he put forward exchanges as a possibility. Why not wallet providers in this case is a similar sort of proxy accountability mechanism. So I will point to that article and I will share it in the chat. And I think it's an interesting area to explore. And I would love to have a copy of the PhD thesis once it's ready.
Okay. Anyone else from the panel? No. Let me see. I think those were the questions that so far were asked. With regard to the last question, it also deals with the more regulatory aspects. Now, Martin, perhaps you could say a few words about how our work relates to regulatory aspects. You said, well, basically, we are aware of that regulatory aspects are definitely to be looked at, but our focus is on private law as such, so particularly contract law. Right or not?
Yeah, absolutely. I mean, that sums it up perfectly and describes our scope. So we will focus, we will touch upon regulatory areas as we are doing it right now, also in the report, and maybe a direct, see one or the other question that is related to the regulatory aspects, and maybe to have some kind of further research in that topic. But our project focuses on the private international law topics and private law topics, not only private international law. And I think we have lots of problems to tackle in this area before we could have a look at other aspects. But I think it would be a good idea to maybe connect with other projects even closer, to have a more holistic approach also in the regulatory aspect field, and probably other projects could also benefit from our work in the private law sector. So I think that is also something that this panel showed, that it would be good to have some further connections with other projects.
Okay, thank you, Marty. Now, at the beginning of the project, we looked at 3 approaches, right? We looked at the private law approach, which we now take, the regulatory approach, which we just talked about, but also the sandbox approach. And we put the sandbox approach completely aside because we felt that that was not a good way forward, and that so far sandbox approaches didn't really work. Now, I would be interested to hear from both Marina and Claudia what they think about the sandbox approach. Marina, perhaps you first?
Yes. So I would put forward that the idea that regulatory sandboxes can actually be a good tool for experimentation and for engaging the stakeholders in a very go-to-market approach. So I don't think it's the only tool in the toolkit if you have it, but we have seen jurisdictions that have used regulatory sandboxes with quite a lot of success. And I'm referring whether to the FCA in the UK or the Monetary Authority of Singapore in Singapore, where they have had a very specific approach of including a wide range of stakeholders and really working together with startups, attracting high quality, also large corporates on advisory boards. So they have done a very concerted, structured approach to regulatory sandboxes, so that they can actually go out there and almost in a design thinking way, prototype certain solutions, test them in the market, go back and make sort of very measured decisions to approach the market and deploy solutions at scale at some point. So I would say that I would encourage to having that as not the only solution, but one of the solutions to advance collaboration between the public and the private.
Okay, thank you. Claudia?
I definitely agree. And we have now a newborn sandbox, like in Spain and other countries, and it is just for financial topics, for financial issues. And what I think is that it is crucial because we lack some knowledges and competences. And so we need to increase our knowledge about the functioning of the blockchain and the real needs of the businesses. So I think it can be a way for advance in this field.
Okay. Dirk, you would like to add something?
I want to ask a question more, actually, because I'm always intrigued by this concept of sandboxes. But what I understand, the areas in which it works is where you have regulatory authorities which have real competence and intervene in the market. What I don't see is where it works in the area of private law. Because you have a contract, it goes to a court, and it doesn't go to an authority to execute the contract or to intervene in a contract. And how can you do a sandbox with a court? Because you cannot tell a court, do this or that in a much more relaxed way, except by really changing the whole law, which the substantive law which the court applies. So I've never understood how sandboxes work in the area of private law. I understood how it works and it works very well, no doubt, in the area of financial supervisory law or other matters, but private law, I haven't seen that one. So I would be interested to hear how that works.
Okay. Marina, perhaps you would like to react?
Again, I have not seen a precedent in private law, as the two examples I mentioned were both financial authorities. There is a proposal to do so in the context of the European Blockchain Partnership with a mandate that goes beyond just financial services. And perhaps that will be a test on how that would work, because that proposes to cover use cases that go into energy, a highly regulated also sector, health, etc., etc. So I think we're in deep experimentation here. So again, I'm not a lawyer, so I will not be presumptuous enough to presume how that would work in private law. But I think this is an area that in some form, whether we call it a regulatory sandbox or not, we need to be able to engage more between the regulators and the businesses, because this is changing day by day. So unless there's almost a constant organic engagement, the solutions just will always be chasing after the problem.
Okay, thank you. Claudia?
Yeah, I think that it can works better relating to the type, the blockchain itself. So the protocol, how it should be designed for particular needs, for example, in insurance or in other contracts. So I think it's more on the platform than on the content of the contract. The sandbox can help to understand better how to make it work properly, for example, for readability or natural language and some standard clauses, something like this, I think.
Right, okay. Thank you. Well, we are now actually approaching the very end of our webinar. I think this was very fruitful. Martin and I listened very carefully, and I saw Martin taking notes. We also heard very well what the European Commission was saying to us, and we will definitely react. This was, again, an extremely useful session. Thank you so much for participating, and also thank you so much for staying within the time, taking part in the debate. I think we all benefited. Thank you again.
Thank you.
Thank you all.
Have a nice day.
Pleasure to be here.
Thank you. Bye-bye.
Bye.
Thank you again.